Everyone is requested to be seated, please. Good afternoon, distinguished guests, ladies and gentlemen. It is my privilege to welcome you to the second session of Day 3 of the Delhi Arbitration Week 2025, jointly hosted by the Honorable Supreme Court of India, the High Court of Delhi, and the Delhi International Arbitration Center. The theme for this session is both timely and urgent: Seeds of the Future, Actionable Steps for Enhancing the Indian Arbitration Ecosystem. As India positions itself on the global stage, arbitration is no longer just a dispute resolution mechanism. It is a marker of a nation's credibility, competitiveness, and commitment to the rule of law. For India to emerge as a true international hub, we must ask, what makes an arbitral seat world-class? Is it only legislation, or is it the combination of judicial support, institutional strength, professional excellence, and global confidence? Today's discussion will take us straight into the heart of these questions, not just in theory, but through actionable steps that can shape the Indian Supreme Court of India in 2021. During her tenure as a judge, she has authored judgments that reflect both intellectual depth and a profound concern for individual rights and institutional integrity. She is widely regarded as a trailblazer, admired not only for her binding precedents, but also her bold dissents. Justice Nagarathna is poised to play a historic role in the Indian judiciary, as she is set to become the first woman Chief Justice of India in 2027. We could not have had a more inspiring chair to lead this discussion. Following her leadership, we are also privileged to be joined by Honorable Mr. Justice Nikhil S. Kariel, Judge of the Honorable High Court of Gujarat. Born in Rajkot, Gujarat, Justice Kariel attended VB College of Law, Udupi, for his LLB. After an illustrious career as a practicing lawyer in Gujarat for 22 years, Justice Kariel was elevated as a judge of the High Court of Gujarat in 2020. Known for his ability to cut through complexity with precision, he has authored several notable judgments in the fields of commercial and arbitration law that highlight both his doctrinal command and his practical understanding of business realities. His court is known for efficiency, and his approach reflects a keen awareness of the need for speed, certainty, and fairness in modern dispute resolution. What sets Justice Kariel apart is a combination of his analytical depth and his reform-oriented outlook. At a time when India is taking bold steps to present itself as an arbitration-friendly jurisdiction, his voice carries both authority and promise. A warm round of applause for Justice Kariel. Continuing our distinguished panel, we are delighted to be joined by Dr. S. Muralidhar, Senior Advocate and former Chief Justice of the High Court of Orissa. Dr. S. Muralidhar is a distinguished jurist, scholar, and a reformer whose career has left and continues to leave a profound impact on both law and society in India. Dr. Muralidhar began his law practice in Chennai in 1984 and shifted to Delhi in 1987. Referred lovingly by some as India's Lincoln lawyer, a title he earned due to his unconventional chamber in his blue Omni van parked in the Supreme Court parking lot, Dr. Muralidhar was associated with the Supreme Court Legal Services Committee and championed several PILs and pro bono cases, including the case for the victims of Bhopal gas disaster and those displaced by the dams on Narmada. He was the counsel for the National Human Rights Commission and the Election Commission of India, and a part-time member of the Law Commission from December 2002 till May 2006, when he was elevated as the judge of the Honorable Delhi High Court. He served as the Chief Justice of the High Court of Orissa from 2021 until his retirement in 2023. As a judge, he authored some of the most progressive and right-focused judgments of our time, combining legal rigor with a deep commitment to justice. He is equally regarded for his jurisprudence on the commercial side, reflecting the breadth of his contribution. His tenure as the Chief Justice of Orissa High Court was marked by institution building and efforts to make courts more accessible, transparent, and efficient for all. He resumed his legal practice after being designated as a senior advocate by the Honorable Supreme Court in 2023. We are delighted to have him offer his valuable insights today. Please put your hands together for Justice Muralidhar. Next on our panel, we are honored to have Justice Michael Black KC. Justice Black is a towering figure in international dispute resolution with a career that spans over 45 years. Justice Black is a full-time international arbitrator, while also serving as a judge of the DIFC Court of Appeal and judge in charge of the DIFC Digital Economy Court. His practice area includes disputes related to joint ventures, construction, energy, oil and gas, financial services, technology, civil fraud, and asset recovery, among many others. For the last 2 decades, Justice Black has acted as an arbitrator in more than 150 arbitrations across England, Africa, India, and the Middle East, Russia, Singapore, and China, to name a few, under leading institutional rules including the ICC, LCIA, SIAC, UNCITRAL, SCMA, and DIAC. Recognized as one of the most in-demand arbitrators in the UAE, he is admired for being exceptionally fair, measured, and thoughtful, with decades of experience in complex commercial disputes worldwide. He has also shaped arbitral jurisprudence through landmark cases in the English courts and Privy Council, and contributed widely to scholarship, authoring chapters in leading texts on arbitration and ethics. For India, which aspires to strengthen its own arbitration ecosystem, his experience provides valuable lessons in judicial commitment, innovation, and global engagement. We are privileged to have him share his insights with us today. Please join me in extending a very warm welcome to Justice Michael Black. Finally, we are privileged to have Mr. David Quest, KC, barrister at 3 Verulam Buildings, London. Mr. Quest is the joint head of chambers at 3 Verulam Buildings in London and has been a barrister since 1993, taking silk in 2013. Mr. David is a distinguished figure at the forefront of the English bar, with vast experience of complex, sensitive, and high-value litigation and arbitration. He practices across a whole range of commercial disputes with focus on banking and finance, commercial and financial fraud, cryptocurrency, blockchain, crypto assets, and AI. He was appointed as a Deputy High Court Judge in 2023. He has recently been appointed as the UK member of the International Jurisdiction Task Force, which deals with legal barriers in digital trade, smart contracts, and cross-border digital finance. Mr. Quest's career exemplifies the qualities that define a truly international arbitration practitioner: deep expertise, cross-jurisdictional experience, and a keen understanding of what makes an arbitral seat attractive to global parties. His reflections today will offer valuable guidance on how jurisdictions and practitioners alike can foster trust, efficiency, and excellence in international dispute resolution. Ladies and gentlemen, please join me in welcoming Mr. David Quest, KC. Before we proceed further, we also have the pleasure of having Honorable Justice Stephen Geigler, the Honorable Chief Justice of the High Court of Australia, as a dignitary amongst us today. With such an illustrious panel, this session promises to be a defining conversation, one that looks beyond aspiration and charts a roadmap for India to become a seat of the future. It is now my honor to invite our chair, Honorable Miss Justice B.V. Nagarathna, the Judge of the Honorable Supreme Court of India, to open the session. I request the speakers to kindly use this podium. Over to you, Your Ladyship.
Namaskar and a very good afternoon to everybody. My esteemed panelists who have already been introduced, I need not introduce them again. Distinguished invitees, learned Chief Justice of Australia, the esteemed guests here, delegates, ladies and gentlemen. It is truly a privilege for me to deliver the opening remarks as chair of the panel on Seats of the Future actionable steps to enhance the Indian arbitration ecosystem as a part of the Delhi Arbitration Week 2025. I deem it an honor to be a part of this cross-exchange of ideas on topics such as the one at hand. At the outset, it would be meaningful to acknowledge the inherent ambition contained in the framing of the topic itself. That is, with the right approach and by undertaking appropriate steps, India may become a seat of the future to conduct arbitrations. I leave it to my esteemed panelists to define and give the meaning of the seat of the arbitration and venue and the various other nuances of it. But I would straightaway go to the fact that this topic calls for a lot of introspection as to how India can become a preferred seat to conduct arbitrations in future. With this goal in mind, there is a need to evaluate the idea of the Indian arbitration ecosystem. For India to become a seat of the future, any myopic focus on a single stakeholder on issue would be insufficient in my view. What is often touted as one of the most significant barriers in enabling India's rise as an arbitration hub is excessive judicial intervention on the part of the Indian courts. Despite a catenary of judicial dicta that recommend a hands-off approach to arbitration in India, thereby envisioning the role of courts as more facilitative than interventionist, there is an unfortunate trend where challenges to arbitral awards have become quite commonplace. I'm informed that a recent study took place with regard to the judgments of the Delhi and Bombay High Courts as illustrations, where over 40% of the arbitral awards under challenge has subsequently been set aside. Further, the existence of a tiered system of review under Section 34, Section 37 of our Act leads to the award taking several years to attain finality and frustrating the very purpose of arbitration, enabling the speedy resolution of disputes, a mirage. However, I would be remiss to also not acknowledge the need for courts in India to possess some form of limited and principled oversight over the arbitral process. This exercise has been undertaken by Parliament itself in the amendment made to the Act in 2015, 2019, and 2021. I would not like to go into the details of various case law on this point, because this is an enlightened audience dealing with arbitration, except refer to Bharat Aluminium Company, Sayong Engineering, Vidya Drolia, Cox and Kings Limited, NN Global, and Gayatri Balaswamy recently, where the spirit of general non-interventionism is apparent. This is critical because the courts must remain vigilant to their largely supervisory capacity, as well as the fact that arbitration functions as a parallel and not necessarily subservient mode of dispute resolution and should be respected accordingly. I think Justice Black was expressing a while ago that arbitration is not an alternative to adjudication, but something which is parallel to court-related adjudication. But why is it that the courts are intervening? I would like to spell out some of those reasons. One of the reasons, according to me, goes directly into the integrity of arbitrators and as to how we can cure that. This is a critical element in ensuring India's status as seat of choice for parties which seek to arbitrate, and hence a bolstered reputation of the pool of arbitrators in the country is required. Let me be frank about this aspect. It is indubitable that there is no dearth of talent, skill, and experience possessed by the arbitrators in this country that rival any of the best in the world. However, aside from being sufficiently professionally competent, there is a dire need for arbitrators to act with an unequivocal commitment to fairness, ethics, and independence. An unimpeachable record forms the linchpin in ensuring the faith of the parties in the arbitral proceedings, and concomitantly, that they are more likely to accept the arbitral award thus rendered. When arbitral awards are questioned before the courts, one of the aspects which are raised is with regard to the fairness of the entire process, apart from the substance of the awards being not in accordance with law or public policy. That is where I would say that an arbitrator must seek to always be prompt in his or her disclosure of potential conflicts of interest right at the very beginning of the process. Always ensure that principles of natural justice are complied with. Must not favor any one party or their position prematurely. Must maintain the highest standards of professionalism in all of their dealings. Must author awards in accordance with the established jurisprudence in a manner that is tailored and unique to the circumstances and facts of the case at hand and is sufficiently well reasoned. Must be accountable for their actions and must strive to always protect the confidentiality of the arbitral proceedings. I would say that the quality of the arbitral award would ultimately have a bearing on the intervention being made by the courts. If the awards are of a high quality, automatically the intervention of the courts would be very, very less. Therefore, it is the duty of the arbitrators to ensure that their awards are of the highest quality, and the process of writing the award is also of the highest quality. Let me tell you, when we are judges, when we are advocates, when we are practicing law in a court of law, we have a rigor and a discipline. But is that missing in an arbitration process? If so, then who should do the introspection? Not just the advocates who are appearing before the arbitrators, but it is my humble opinion that the arbitrators themselves must introspect as to how they can attract more arbitration to this country. Every arbitrator must bear in mind that their conduct has a direct bearing on the perception of India's potential as an arbitration hub. Considering that a large proportion of arbitrations in India are ad hoc in nature, the possibility of development of a formal code of conduct that would serve as a guide to such arbitrators in India must be explored. I would appeal to this conference that let there be a resolution passed that a formal code of conduct would be made, if not already there, or if it is there in a very fluid state, for the arbitrators to follow in the future. A related concern is that of diversity in the pool of arbitrators. Arbitration cannot be the domain of retired judges as well or well-established names alone in the legal field. This is not merely in the interest of equality of opportunity, but also serves the purpose of ensuring that specialists in their field, which may even include non-lawyers entirely, are able to provide their invaluable insights, especially into sector-specific arbitration, and that may be technically complex. I think Mr. Quest will be speaking about this. A successful arbitration hub needs a deep pool of skilled professionals, and this involves continuous investment into the growth, upskilling, and professional development of the next generation. In this regard, I think that the establishment of a dedicated arbitration bar of India is an incredibly favorable step. It is a recognition of the need for career arbitrators and not merely those who practice arbitration after the day in court has concluded or as a weekend affair. While there have been many strides in this respect, it is unfortunately the case that arbitration continues to be a male-dominated field. It is critical that both more women are appointed as arbitrators, and any explicit or implicit biases or roadblocks that prevent the possibility of their appointment must be swiftly and thoroughly addressed. And also the younger women receive the requisite access to opportunities that will enable them to be appointed as arbitrators in the future. By prompting diversity in the practice of arbitration, we can create a more inclusive, effective, and legitimate dispute resolution process. Justice Kariel would be speaking about timelines and costs, but I would just like to hint by saying that timelines and costs are hindrances that serve as roadblocks to India's hope to becoming a global hub for arbitration. There must be a recognition of the fact the delays in arbitral proceedings and non-compliance with the timelines have a bearing on India's perception as a desired seat to conduct arbitral proceedings. This issue of costs is another major advantage in one sense and a disadvantage in another. It is an advantage because India serves as a desirable seat for the conduct of proceedings which can be conducted in a cost-efficient manner as compared to overseas arbitration. But the speedy conclusion of the arbitral proceedings is critical in ensuring this key selling point of lowered costs. Another aspect is ensuring sufficiently deterrent costs are imposed in case of wholly frivolous and unmeritorious challenges to arbitral proceedings. Let me introduce another idea to this enlightened audience, which is institutional versus ad hoc arbitration and the merits and demerits thereof. It is an undeniable fact that today the majority of the arbitrations in India are conducted in an ad hoc fashion, and the entire process is dependent on party cooperation and consent. But what happens when there is lack of cooperation and consent between the parties? A possible solution to this is to actively promote institutional arbitration. With institutional arbitration comes some guarantees of professional management, common rules applicable to all, usually a pre-existing set of arbitrators that have been vetted and have a track record, certainty of the process, procedural fairness, and shorter timelines. India's existing arbitral institutions such as the ICA, MCIA, IIAC, DIAC, that is Delhi International Arbitration Center, must be bolstered and popularized so that more parties are aware of the option to opt for an institutionally administered arbitration. A large number of arbitral institutions with empaneled arbitrators must be established, not just in the usual branches of law, but even in niche areas such as technology law. Moreover, these institutions must have state-of-the-art infrastructure and logistical and technological facilities. Then only they would inspire confidence and the arbitrations would be fair, transparent, ethical, accountable, and efficient. One other idea that I would like to place on the table is with regard to a meaningful step in enhancing Indian arbitration ecosystem is to promote mediation as a parallel mode of dispute resolution, especially through the inclusion of multi-tiered dispute resolution clauses. Incorporating mediation either as a mandatory step before deciding to arbitrate or as an option available to amenable parties after the arbitration process has commenced would allow for even quicker resolution of disputes and has been statutorily recognized as permissible even under Section 30 of the Act, especially in cases where expediency or preservation of the existing relationship between the parties is of importance. Arbitral institutions must provide the option of parties to be able to opt for mediation. Therefore, qualified mediators also forming part of the institutional apparatus would likely further truncation of the process and efficient resolution of the dispute. I wish to take this opportunity to re-emphasize the need for various stakeholders to collectively participate in the shared vision of making India a global hub for arbitration. The vital requirements of a well-functioning arbitration ecosystem, namely finality, structure, credibility, legitimacy, efficiency, professionalism, and a culture of resolution are interlinked and are dependent on institutional integrity, judicial restraint, technology, and infrastructural development in turn. Arbitration in India must become faster, fairer, cheaper, and more credible so as to inspire confidence in parties, both domestic and international, to choose India as a seat. While there are miles to go in this regard, I am an optimist and confident that India would be a seat of the future in future, and this is within the reach of our combined efforts, commitment, and innovative thinking. I with this, I close my address. I thank each one of you for your kind patience and hearing. Namaskar.
Thank you, Your Ladyship, for those insightful remarks. I now invite Justice Michael Black to take the podium, please.
Thank you. Chief Justice, Chief Justices, Supreme Court Justices, distinguished guests, it's a great privilege to be addressing you today. It has been also my privilege to have sat as an arbitrator in India for nearly the last 20 years, and I yield to no one in my admiration of the skill and expertise of the Indian lawyers who've appeared before me. And indeed, I do feel that it would be impertinent for me as a guest and enjoying your warm hospitality to make any comments whatsoever upon the Indian legal system or the way in which it addresses arbitration. And so what I propose to do is two things today, is to talk at quite a high international level on the features of a jurisdiction that make it an arbitration-friendly seat. And then briefly, just to touch upon something that our learned chairman referred to, the difference between institutional and ad hoc arbitration. All of my arbitrations in this country have been ad hoc, whereas in fact most of my arbitrations in other jurisdictions are institutional. I'd just like to compare, very briefly if I may, the differences between the two from personal experience. I hope therefore that I will be in a position to frame the debate from those who follow, who are able as members of this vibrant legal community to make their own comments upon the way in which it embodies or does not embody some of the features that I'm going to address now. And I'm particularly assisted by something that occurred 10 years ago. 10 years ago was the centenary of the Chartered Institute of Arbitrators. And they produced what they called the London Centenary Principles 2015. Let me read to you the subscription under those principles and why I refer to them. The following principles are those necessary for an effective, efficient, and safe seat for the conduct of international arbitration. And so I said the work has already been done for me by a very distinguished panel of international arbitration practitioners. And I'd just like to run through the 10 principles that are embodied in those Chartered Institute principles. And the first one is law. And they say that what is required is a clear, effective, modern international arbitration law, which shall recognize and respect the parties' choice of arbitration as a method for settlement of their disputes by A, providing the necessary framework for facilitating fair and just resolution of disputes through the arbitration process, B, limiting court intervention in disputes that panels have agreed to resolve by arbitration, and C, striking an appropriate balance between confidentiality and appropriate transparency. I think probably India is already there with that. The 1996 law and the subsequent reforms have given India, at least in my experience, a world-class arbitration law, and I say no more about that. But I'll move on to perhaps the slightly more contentious area, which is Principle 2, judiciary. What the guidelines say is an independent judiciary, competent, efficient, with expertise in international commercial arbitration, and respectful of the parties' choice of arbitration as their method for settlement of their disputes. Now, again, our learned chairperson referred to something I'd said to her earlier about many judges regarding arbitration as ADR, and ADR as alternative dispute resolution. There are two errors there, if I may say, first of all. ADR as alternative dispute resolution is a very, very old-fashioned phrase, and it is wrong. And I think most thought leaders now are moving to define ADR as appropriate dispute resolution. And that actually goes back to its origins. When you go back to the Harvard Pound Conference, back to 1975, when they talk about the multi-door courthouse, the idea is that disputes should be decided appropriately. And there are many different routes. One of those routes is arbitration. But the other error also, in my judgment, of those judiciaries throughout the world that regard arbitration as an alternative and even a competitor to court litigation is they don't often understand seat theory. Because the fact is that those courts would not have jurisdiction at all over the dispute in many cases, but for the fact that the parties had nominated that seat within their arbitration agreement. And if you just looked at the national laws and you looked at the international parties, the court wouldn't have jurisdiction at all. So in fact, the court of the seat is not an alternative to the arbitral process. It is part of the arbitral process. It is actually there to support arbitration, not to regard it as a competitor. And so judges in many jurisdictions that I've come across have to learn that it's not a matter of arbitral tribunals trying to steal their work. It's actually a matter of people choosing appropriate dispute resolution and then choosing the court that supports them in that choice. Moving on, a linked point to that is legal expertise, an independent, competent legal profession with expertise in international arbitration, international dispute resolution, providing significant choice for parties who seek representation in the courts of the seat in the international arbitration proceedings conducted there. Again, I think actually India has hit the ball well over the boundary there. As I say, I yield to no one in my admiration of quite how smart Indian lawyers are. Can I just actually pick a point up as well in terms of court intervention before I move on to the next point, and give you some statistics, if I may. There was a survey of the English Commercial Court, and of course we know the vast number of arbitrations that happen in London. Again, we heard a moment ago that 30% of cases before I think it was the Delhi and Bombay High Court are set aside on enforcement. Let me give you the English statistics. So there are three routes, essentially, to challenge an arbitral award. I'm not going to talk about enforcement. So there is Section 69 of the English Act, which is an appeal on a point of law. And you have to get through quite a high bar, even to get permission to appeal. So it has to be a point of general importance before the court will even entertain the appeal. And there again, it actually is quite a similar statistic. About 30% of those cases do end up being found against the award, as it were. But remember, they've been filtered. But I need actually to look at the numbers, because the numbers tell the story rather more significantly. In 10 years, when one was looking at appeals on the point of law, so on Section 69, there were only 126 cases filed, let alone decided. And when you think about the number of arbitral awards and cases that are carried out in London over a 10-year period, it is a minuscule proportion that actually even get to court, and then a very small proportion of those that get to court actually result in the court interfering with the award. The figures are even lower when you get to due process challenges and when you get to jurisdictional challenges. So due process is dealt with under Section 68. Under Section 68, only about 11% of cases were successful. and only 105 challenges were brought in 10 years before the English court. And then finally, on jurisdiction, about 15% were successful, but then only 92 cases were ever referred to the English court in that 10-year period. So it's a very different ecosystem indeed when you think about the data there and the number of challenges that people are actually bringing to the court and the filtration process that goes on. So moving through the London principles, if I may, the next one is education, I think, which is self-explanatory. The next one is the right of representation, a clear right for parties to be represented at arbitration by party representative, including but not limited to legal representation. So the recognition that parties can be represented by people who are other than lawyers in the arbitral proceedings. Accessibility and safety. Easy accessibility to the seat, free from unreasonable constraints on entry, work, and exit for parties, witnesses, counsel in international arbitration, and adequate safety and protection to the participants, their documentation information. Now, we have in England encountered difficulties actually with visas for participants in arbitrations from India. I mean, that has been a problem in cases that I've come across. So England doesn't satisfy Principle 6 at the moment in relation to India. That must change. Visas can be a great problem. In some jurisdictions, counsel cannot appear before a tribunal unless they co-counsel with a local lawyer. Obviously, that's to make sure that somebody gets a slice of the fees locally. But happily, India again does well on number 6. 7, facilities. Functional facilities, provision of service to international arbitration. We're seeing the growth of that certainly here. Ethics, to touch upon something again that our learned chair touched upon. Professional other norms which embrace a diversity of legal and cultural traditions and developing forms of international ethical principles governing the behavior of arbitrators and counsels. Then 9, enforceability, adherence to international treaties and agreements governing and impacting ready recognition and enforcement of foreign arbitration agreements, orders and awards made at the seat in other countries. I'm going to tell you something which is going to give you a warm feeling of pride when it comes to enforceability. I'm not going to name the country, but I had a case, actually, ultimately, which went to the English Supreme Court, where the former Chief Justice of a particular country gave evidence to the Supreme Court in England, saying that in his country, in order to challenge an arbitral award, it would take 40 years. That's 40. So India, I think, is doing very well by comparison to that. Of course, we can all speed up our processes. And indeed, going to my own second jurisdiction, the UAE, the federal arbitration law, which is a modern model law-based law, imposes time limits which are quite strict. So, for example, if you wish to challenge the appointment of an arbitrator, the court is bound to issue its judgment within 15 days. So those are the sort of timelines that we like to see as arbitration practitioners. So with minimum interference in the overall procedural timetable. And then finally, immunity, a clear right to arbitrator immunity from civil liability in anything done or omitted to be done by the arbitrator in good faith in his or her capacity as the arbitrator. And we do have challenges in relation to that all over the world, and we do have it in my adoptive region. There have been some very well-known cases in which arbitrators have found themselves on the end of criminal complaints in certain Middle Eastern jurisdictions, which have been most unfortunate. But I think we're moving away from that. In the last couple of minutes I have, can I just share 10 principles briefly for me which commend institutional arbitration over ad hoc arbitration? Each one of these embodies a problem that I have come across in my career. So first of all, institutional arbitration provides a transparent and predictable costs estimate for the parties. Otherwise, parties can find themselves going down a road and then, years later, finding themselves, we've spent so much we didn't anticipate. So a good institutional guideline as to costs is a great encouragement to parties to use arbitration, to businesses to use arbitration. Secondly, a body that has fixed procedures for dealing with the appointment and challenges to arbitrators. And this is a bitter experience that I've had in the last couple of weeks, actually, in an ad hoc arbitration, where it's necessitated court interference, whereas matters would have been dealt with so much more quickly by an institution. A ready-made set of procedural rules that are compliant with the law of the seat. It forestalls a great deal of argument, ultimately, if you can say, well, ultimately, we can default to a set of rules by the institution if the parties can't agree the procedural rules. 4, a secretariat available to assist with the administration of arbitration, especially the financial aspects. Again, very helpful. I sit in Singapore. I had to fill in my withholding tax form this morning in relation to a particular matter, but it's great because the SIAC assists me and my practice manager in relation to taxation matters, which, of course, you're left on your own if you're on an ad hoc arbitration. And then a rather more contentious issue. I sit on what is effectively the court or the managing committee of a particular arbitral institution. And we had an internal debate last week as to how far we can control the quality of arbitrators actually nominated by the parties. And the reality is that arbitral institutions do sometimes go back to the parties and say, yes, okay, you've nominated X, but perhaps you'd like to rethink about that X may not have experience, and there is an institutional knowledge there that some arbitrators are quite well-known arbitrators, either too busy or they farm out their awards to other people to write for them, or they're just not very good. And actually, most institutions do have quiet words with parties about that. So there's informal guidance there. There's assistance in the formal necessities for an enforceable award. The ICC particularly is very good. When they scrutinize your award, they have lawyers from the jurisdiction where the award will be enforced. And they help you, when you're writing your award, write an award which will be enforceable in that jurisdiction. And of course, the ICC also, and SIAC, and to a slightly lesser extent, LCIA and the other DIAC, they scrutinize awards, which are very great help. I mentioned assistance with tax, which is very dear to my heart. And then finally, the one thing that I think is terribly important is that it's all underpinned by an accumulation of institutional knowledge. And so long-standing institutions like the ICC, like SIAC, like Dubai International Arbitration Center, like the LCIA, they have an institutional knowledge which benefits the parties and benefits the arbitral tribunal. And that's lacking in ad hoc arbitration. So I really can't commend too highly from the point of view of the arbitrator, from the point of view of the judge too, and I think also from the client's point of view, and they're the most important people, ultimately, at the end of the day, that institutional arbitration really does have very, very significant advantages over ad hoc arbitration, and that is perhaps a goal that this jurisdiction might perhaps aim at. Thank you very much for your time.
Thank you, sir, for such a compelling address. To add another perspective, I now invite Justice Kariel to take the stage, please.
A very good afternoon to all. Honorable Mrs. Justice B.V. Nagarathna, Judge, Supreme Court of India and esteemed chair of this session, my esteemed panelists, judges of the Delhi High Court, MP High Court, Madras High Court, delegates, ladies and gentlemen. I'll be speaking about what ails the Indian arbitration ecosystem and the possible remedies from the perspective of making India an attractive seat of the future. As we all know, and as said by the esteemed chair and my fellow panelists, arbitration is no longer a peripheral mechanism for dispute resolution. It has become the backbone of cross-border commerce, the first choice of parties when structuring complex transactions, and in many ways the defining feature of international dispute resolving mechanism. When we speak of seats of the future, we are really speaking about how a jurisdiction positions itself as the natural home for resolving disputes that transcends borders. London, Singapore, Paris, Hong Kong have established themselves as leaders in the field, drawing parties from every continent. The question before us is simple. Why not India? For India, with its growing role in global commerce and investment, arbitration is just not an alternative, it is a necessity. And yet, our ecosystem continues to face challenges. International parties often hesitate to choose India as their preferred seat, citing concerns of delay, excessive intervention, and procedural inconsistencies. If India is to become a true hub of international arbitration, we must take a hard look at what ails the system and how these gaps can be remedied. As John Dewey rightly observed, a problem well stated is a problem half solved. It is a powerful reminder that clarity is the first step towards resolution. Before we can fix anything, we have to be brave enough to name it, face it, and understand it. That is where the real momentum begins. Keeping this in mind, I propose to identify 5 crucial issues that afflict Indian arbitration and the possible remedies. The first issue that afflicts the Indian arbitration system, I believe, is the dominance of ad hoc arbitration. Ad hoc arbitration continues to dominate in India, but it suffers from multiple structural weaknesses. Proceedings are often delayed due to lack of fixed timelines for appointments and hearings. Costs can spiral because there is no transparent fee structure, and procedural choices vary widely, leading to inconsistency and unpredictability. The second is, I believe, delay and absence of structured timelines. What lies at the heart of arbitration is its promise of speed and efficiency. Yet, in India, delays occur at every stage. Appointment of arbitrators, exchange of pleadings, scheduling of hearing, and even delivery of awards. Despite statutory timelines, deadlines, extensions are often sought and granted, eroding faith in the process. Unlike Singapore or Hong Kong, India lacks a culture of strict adherence to phased time-bound procedures. The third, I believe, is the execution of arbitral awards. Under the present system, arbitral awards are enforced as civil decrees. While this may appear logical, in practice, it brings back awards back into the congested machinery of civil courts. Execution proceedings often become as protracted as original litigation, negating the very advantages of arbitration. This is one of the most frequently cited reasons why parties avoid India as a seat. They fear that even after succeeding, enforcement will be slow and uncertain. Fourth is excessive judicial interference. It may seem paradoxical that even though I sit as a judge of the High Court, exercising powers under Articles 226 and 227 of the Constitution of India, I subscribe to the view that such powers must be exercised sparingly in arbitration ecosystem. Despite progressive jurisprudence, courts in India continue to intervene in arbitration proceedings by exercising their powers under constitutional provisions. While well-intentioned, such interference dilutes party autonomy and creates uncertainty. The frequent invocation of these powers creates the perception that in India, arbitration is never truly final. This level of interference contradicts the very essence of arbitration as an ADR mechanism, thereby diluting its effectiveness. Fifthly, and most importantly, is concerns regarding arbitral quality. I know I may be stepping on a few toes here. However, it is pertinent to acknowledge that there are concerns regarding the quality and independence of arbitral awards. Arbitration thrives on the confidence that each tribunal will examine the record before it will render an award independently. Unfortunately, there have been instances where this expectation has been compromised. Instances of poorly reasoned or even plagiarized awards have surfaced. In a similar vein, in my own experience, sitting as a judge, I have come across a matter where two separate arbitrations were conducted. The opponents were different and two arbitral tribunals were constituted, each comprising 3 members. One arbitrator happened to be common to both the tribunals. What followed was concerning. One tribunal declared its award, but in doing so, it relied heavily on the reasoning contained in the draft of the second tribunal's award, even though the second tribunal had not declared its award. Such episodes demonstrate why judicial supervision, though minimal, must remain available for exceptional cases to step in only when integrity of arbitral process is at stake. Now to the remedies and the path forward. The first remedy, I believe, is institutionalization of arbitration. We must promote institutionalization of arbitration and encourage the creation of new arbitral centers. The involvement of private players in establishing more centers can diversify the arbitration landscape and bring innovation. Institutions ensure predictability, professional case management, and quality assurance. Encouragingly, the India International Arbitration Center offers structured rules, training, and a panel of accredited arbitrators. Additionally, to encourage a robust domestic arbitration environment, institutional arbitration can be made mandatory for specific type of disputes. Second is ensuring quality and integrity in arbitration. Beyond institutionalization, focused steps are needed to safeguard the quality of arbitral awards. Arbitral institutions should set clear eligibility and evaluation standards, introduce scrutiny of draft awards to prevent plagiarism and poor reasoning, as well as require greater disclosure of concurrent appointments. Encouraging specialization among arbitrators and involving eminent academics for their expertise can further enhance standards. At the same time, institutions may consider adopting accountability mechanisms to ensure consistency and integrity without undermining their independence. For instance, the HKIAC under Articles 13.10 of the 2024 rules has a new power to take any measure necessary to prevent the efficiency or integrity of the arbitration. Third, a hands-off judicial approach. Courts must reinforce the principle that arbitration is final and binding. Intervention should be reserved for exceptional circumstances, not routine oversight. Minimal interference does not mean abdication. It means respecting the autonomy of the parties and intervening only where justice demands it, like intervening at the stage of Section 9, but minimal intervention 4 and 37. Judicial training, specialized arbitration benches, and consistent jurisprudence are essential to building this culture. The fourth remedy would be accelerated and phased procedures. Like SIAC's expedited and streamlined processes, India must divide arbitration into clear stages. Appointment with a fixed time, pleadings within set months, hearings on limited schedules, and awards within a strict deadline. SIAC offers an expedited procedure option for parties to resolve their disputes within 6 months, and recently, the 2025 rules have also introduced a streamlined procedure where an award is ordinarily issued within 3 months. By the same token, the 2024 draft arbitration bill introduces reforms such as fixed timelines and emergency arbitrators. Such measures underline the fact that our policymakers are alive to the challenges faced by the Indian arbitration ecosystem. Fifth would be reforming enforcement and appellate mechanisms. Delays often arise because execution follows complex civil decree procedures and courts apply broad grounds of review, especially under the public policy exception. Civil courts can have exclusive jurisdiction to execute arbitral awards, but this process should be structured and with a statutory timeline. Specialized arbitration benches can ensure consistency. Technology such as e-filing and digital tracking can streamline processes. Finally, costs and sanctions for frivolous challenges would deter delay tactics. Together, these steps can ensure that enforcement in India is swift, predictable, and globally trusted. The 2024 draft amendment bill proposes the creation of an appellate tribunal for arbitration matters. This is a progressive idea. Rather than every award being tested in overburdened courts, a specialized tribunal can hear appeals quickly and consistently, provided that such an appellate procedure can be invoked only when the parties have expressly agreed to it in their arbitration clause or agreement. Additionally, the presence of such an appellate mechanism would allow curtailment of appeals under Section 34 and 37 of the Arbitration Act, reducing unnecessary litigation. Taken together, these reforms outline the path forward, addressing the issues we have discussed and laying the foundation for a stronger, more reliable arbitration framework. In conclusion, in India, arbitration holds immense potential, yet it must rise to fulfill its promise. The issues outlined earlier have at times eroded confidence in the system. Yet, the remedies lie within our grasp: institutionalization, judicial restraint, time-bound processes, stronger enforcement, and continuous professional development. We should embrace reform to achieve the twin objectives. First, to make arbitration faster, more affordable, and more reliable, ensuring that parties choose India as their preferred seat. And second, to build an ecosystem that inspires confidence among businesses and global investors. The 2024 draft amendment bill is a significant stepping stone, but as this discussion has highlighted, much work remains on the horizon. While the world looks to London, Singapore, and Paris, there is no reason why it should not look to India tomorrow. To chart this ambitious path, we must remember the wisdom of Winston Churchill. To improve is to change, to be perfect is to change often. Let us move forward this with courage, clarity, and resolve, for it is through thoughtful reform that India can claim its rightful place as a global hub of arbitration. Thank you all.
Thank you so much, sir. Your address has given us a lot to reflect on. I now invite Mr. David Quest to address us. Please welcome him with a warm round of applause.
Thank you. It's a great privilege and a great pleasure to speak on such a distinguished panel and to such a distinguished audience. The last decade has witnessed a phenomenal surge in the digital asset market. From a nascent concept in 2009, cryptocurrencies alone have achieved a market capitalization exceeding $3 trillion. And this is a growth that's proved astonishingly resilient, undeterred apparently by market volatility and by the many serious instances of insolvency and fraud. And inevitably, this rapid expansion is leading to a new wave of complex commercial disputes, many of which, as one might expect, are being channeled towards arbitration. And as a country in the forefront of technological development with an enormous technological industry, India should expect to have its share of these arbitrations. And it's arbitrations about novel technology disputes that I want to talk about today. I should say, of course, that digital assets are just one aspect of the novel technologies that are reshaping our commercial landscape. We have to contend now, or will have to contend in the near future, with disputes concerning smart contracts, blockchain, algorithmic trading, and of course, artificial intelligence. And while technology-related disputes are not new to arbitration, the current wave of novel technology disputes does present some unique challenges. And we're now encountering disputes that are not only profoundly technical in their subject matter, but also raise some novel and difficult legal and procedural questions. For example, we have disputes where the corporate structures of the parties may be unconventional. We see ownership and governance rights in businesses tied to digital tokens on a blockchain rather than to a conventional shareholding. And we've seen the emergence of decentralized or autonomous organizations, as they're so called, which are organizations operating entirely algorithmically, lacking any traditional legal form. And of course, contracting processes are also evolving. As I've mentioned already, parties may use self-executing smart contracts to trade with each other, and may even employ autonomous agents, perhaps artificially intelligent agents, to form agreements. And anonymity in trading on the blockchain further complicates the process of dispute resolution. And this new dispute landscape also brings with it, and I speak from personal experience, a new type of litigant, often entrepreneurs with a very high level of technical expertise, immersed in the culture of technology, who are often impatient with what they perceive as lengthy and inflexible arbitral procedures that are too paper-based and don't make sufficient use of technology in the dispute resolution context. And they're also likely to want their disputes resolved by arbitrators with a similar level of technological awareness. And this demand for technological fluency in arbitrators goes beyond just digital literacy. Litigants may be looking for arbitrators who have a sophisticated understanding of the underlying technology, whether that's the architecture of the blockchain, the operational logic of a smart contract, or novel governance structures, which understanding is important not just for evaluating the merits of the dispute, but also for crafting appropriate case management and procedural strategies, for example, in relation to disclosure of specific forms of digital evidence. And I mean, one gets an idea of the mindset of some of these litigants from what's sometimes called the code is law movement, which argues that actually technology can resolve its own disputes entirely through the underlying code without the involvement of lawyers at all. Now, of course, this is heresy to lawyers. We understand that no dispute, however technical, is immune from judicial or arbitral supervision. But it does perhaps highlight a growing dissatisfaction with conventional dispute resolution. So that's a problem. What's the issue? What are the actionable steps for enhancing the Indian system in response to these challenges? Considerations of the kind that I've been discussing led a body in the UK called the UK Jurisdiction Task Force to propose a set of what were called digital dispute resolution rules, a set of arbitration rules aimed at technology disputes generally, but at novel technology in particular. The UK Jurisdiction Task Force is an industry-led initiative. It was established in 2020, and it's tasked by the UK government with promoting the use of common law and common law jurisdictions, particularly the UK, for technology and digital innovation. It's chaired by Sir Geoffrey Voss, the Master of the Rolls in England, and its purpose is to clarify key questions regarding the legal status and the basic legal principles which apply to crypto assets, distributed ledger technology, smart contracts, and associated technologies. And it has it's produced a number of papers on law and procedure in this field, which, if you're interested, you can find on the website at lawtechuk.io. But focusing on what we've done at the UK Jurisdiction Task Force in relation to arbitration, the digital dispute resolution rules that we've proposed are intentionally short and confer maximum discretion on arbitrators with minimal hard-coded procedures. The default timetables are significantly condensed, measured in days rather than months, and the approach is intended to empower a tribunal, once appointed, to take immediate control of the arbitration and design a bespoke procedure as concise as may be appropriate for the case. This, of course, relies on the ready availability of qualified arbitrators, and to this end, the rules include an appointing body which maintains a roster of arbitrators with appropriate qualifications and skill who are prepared to be appointed and to act at short notice. And in England, we have as an appointing body the Society of Computers and Law. The whole approach is deliberately in contrast with the typical arbitration procedure, where one has an extended period of negotiation over who is to be appointed, followed by often a lengthy process of appointment, and then exchange of written statements of case, so that one is normally a number of months in before the arbitrators even begin to make decisions about case management. And then the decisions that they typically make usually involve further lengthy exchanges of documentary materials. So there's an opportunity to try and cut through that in appropriate disputes. There are also several novel features of these rules, which I think are worth highlighting in terms of the discussion we've been having. First of all, some digital asset systems have dispute resolution processes built into them. This is sometimes called on-chain dispute resolution. So, for example, a participant in one of these novel systems may be able to trigger a decision on a dispute from within the system itself, which then gets decided by an external arbitrator or adjudicator. And we even see in some systems a kind of jury process where token holders or participants in the system get to vote on the outcome of disputes. And mindful of these, the digital dispute resolution rules recognize and give legal effect to those kind of unusual processes. And we also see in some digital asset systems, there's a control mechanism which allows the arbitrator, through holding a special private key code, to implement decisions they make directly on the blockchain or directly within the system. So having made, for example, an award or made a decision to the effect that a particular transaction should either be cancelled or confirmed, the arbitrator could then immediately execute that award through the blockchain. And again, the rules anticipate that. They also take account of the fact that in these systems one may have tokenized rights that are widely traded, and the dispute resolution system ought in principle to be binding on all parties who acquire the token. We also had regard to the fact that in an appropriate case, it may even be possible for the parties who have dealt with each other, perhaps anonymously on a blockchain, to remain anonymous to each other during the arbitration process, although, of course, they must disclose their identity to the arbitrators. Finally, although there's one area which is not expressly covered in the rules, clearly AI is increasingly important. I know you've just had an extended session on the use of AI, but as I see it, there are two aspects that really need careful consideration within the arbitration ecosystem. One is the use of AI to enhance the arbitral process, but the other is how to efficiently deal with disputes that arise from the use of AI. Again, anticipating in a world in which there will be trading, there's already trading, between autonomous artificially intelligent agents. Now, I should say, I've explained these rules as a sort of example of how one might improve arbitral processes. It's not yet clear to what extent the rules that we've proposed have been incorporated or used, and I'm not suggesting that they're the only way of dealing with novel technology disputes. But they are, I suggest, of considerable interest, of an illustration about how one might approach some of these issues, which will arise increasingly frequently as the digital economy grows. And the features I've described of them may provide some food for thought about how one might ensure that the Indian arbitral system is going to be attractive in this new and expanding market. Thank you very much.
Thank you, sir, for your thought-provoking insights as examples of actionable steps. Finally, it is my pleasure to invite Dr. Muralidhar to share his perspective on the topic. Please welcome him with a warm round of applause.
Thank you. Justice Nagarathna, Justice Kariel, Mr. Black, Mr. Quest, all the distinguished members of the audience. I'm told the menu for the lunch is excellent, so I shouldn't delay that. I'm going to say something which might stand at odds with what all the others have said. I have a problem with the word compete. I don't think we should be in competition. I don't think we should start there at all. Second, I firmly believe if we solve the problems of our domestic arbitration, we will then be able to solve the problems of our hankering for international arbitrations. So I've attended many of these conferences year after year. This theme, particularly how do you make India an attractive arbitration destination, has been analyzed threadbare. And there are fundamental systemic problems that we have, which we need to address. The way the Indian bar is structured, the way the Indian judiciary is structured, it is not capable at this point in time in producing specialist arbitrators and specialist arbitration lawyers. The top practicing lawyers of this country, and I see many of them in this audience, would have argued before a bench of Justice Nagarathna, not only arbitration cases, but even criminal appeals. And tomorrow on her Monday board, Justice Nagarathna herself will have a variety of matters. She will have bail applications, she will have criminal appeals, she will have matrimonial disputes, she will have arbitration disputes. So as persons within the Indian legal system, we expect our good practitioners and our good judges to be generalists and not specialists. So this is a very fundamental issue that we need to address. We're now looking for some exclusivity here. We're looking like in the visa offices, we have premium lounge. So we want that premium arbitration lounge. And it's an exclusivity. It's certainly an exclusivity. Second is the litigating capacity. Persons in arbitration, in international commercial arbitration, are players with excessive litigating capacity, which players in the domestic arbitration may or may not have. So it changes the very nature of that dispute resolution. At the end of the day, arbitration is private dispute resolution mechanism. It happens in a closed space where both lawyers and arbitrators are able to devote exclusive time. You know, judges sitting here in the audience and on the dais will realize that imagine from morning 10:30 to evening 4:30, you're hearing only one case. And for Supreme Court judges who've now stepped off and are arbitrators, it is an adjustment, a reorientation. After hearing some 60 cases a day, now you're going to hear one case from morning to evening. Likewise, for lawyers who are very busy in courts, handling, let's say, 5-10 cases a day, when that 4:30 happens, they have to sit in one place with one case. Whereas internationally, if you're before the ICC and SIAC, both the arbitrators as well as the practitioners would not have anything else on their board. They've devoted exclusive time just for this. So we have to then switch our whole rhythm, which many of us are finding impossible to do. The same lawyers who argue a very intricate criminal appeal during the day in the court are tackling a very complex international commercial dispute in the evening. And this is the fact of the matter. Some of the best legal brains in this country are not specialist legal brains. Likewise, some of the most sought after arbitrators who've been former judges are not specialists in commercial arbitration. They may be good in this, they may be good in something else. So we have to first figure out within the domestic setup, what kind of specialization can we encourage and achieve? If you're able to answer this question within us, in the domestic scene, we may have an answer to the question that's posed for this panel. How do you make India an attractive destination for arbitration? Next is the linkage with money. How much are you able to pay for litigation? Right? You want that special queue. You don't want to join the general queue of cases. So what did we decide as Parliament? We said we'll have a Commercial Disputes Act. We'll set aside some judges sitting on benches, whether in the district courts or in the high courts. We'll form what are called commercial courts. It's the same judges who are going to sit in those commercial benches. Whether Justice Kariel or Justice Anand Venkatesh, 6 months ago, Justice Kariel may have been dealing bail applications. Today, the Chief Justice of his High Court says, you sit in the commercial division. After 6 months, he'll be sitting in the original side or dealing with suits in the Madras High Court, for instance. So the judge cannot be a specialist. So that commercial court, which is dealing with commercial disputes, is not a permanent court. This is the second problem that we have, which resists what we call specialization, whether it's of the bar or of the bench. Third, enforcement was spoken about, and it is a very valid point that you're making, Nikhil. When foreign awards are tested in Indian courts, the Indian judges have a tendency, because of the size of the award, and invariably if it's against the governments or against public sector undertakings, all that the lawyer has to stand up and say, my lord, a 2,000 crore award, 2 billion award. Just the figure, listening from 2,000 crores or 2 billion means, okay, my antenna should be up. I should scrutinize it even more carefully. So the whole approach then becomes very different. Because we're dealing with all other kinds of litigation, we are not oriented specially to deal with arbitration kind of disputes, particularly international and foreign awards. Last point, and I know lunch is waiting for all of us. See, what we do is borrowing. We don't devise our own systems. We've done this right in the beginning. We inherited an alien system for our regular court practices. We have now borrowed the UNCITRAL model, a model that works wonderfully well for a Singapore or for France or for England or for even the Middle East. It cannot work ipso facto in India. That's devised for a different kind of a system where they value time and costs. Here we give adjournments because the lawyer's daughter has got a +2 examination the next day. So we have to indigenize. We have to customize whatever we've borrowed for the Indian system, but I urge all of us sitting in this hall to think over how we can improve our domestic arbitration in the first place. How can we create those specialized arbitration bars and specialized arbitration judges? Only then we can talk of how to improve our system to attract. Let's look at the medical profession. There's something called medical tourism today in India, because some of the best medical professionals in the world are working in Indian hospitals. And they've not had to do anything special to attract that, right? They have just been very good in what they have been doing in India. And they've acquired a reputation. They're then spoken of. It has its own grapevine, it has its own network of communicating that you get quality medical treatment in India. So if we are able to achieve that level, whether as a bar or as judges, we will automatically attract this so-called international commercial arbitration. So let's get our house in order then other things will follow. Thank you.
Thank you, sir, for such an insightful and engaging address. Ladies and gentlemen, please join me in expressing our gratitude to the chair and our distinguished speakers with a huge round of applause. Now, with the kind permission of the chair, we open the floor for questions from the audience. Please introduce yourself and identify the speakers your question is addressed to. In the interest of time, we request you to keep the questions brief. I see a hand on the right in the 5th row. Yeah. May I request someone to help with the mics? So please.
Well, I'll keep short because now I stand between lunch. And my question is supposed to, our King's Counsels here to share their perspective and perhaps challenge the address posed by Justice Muralidhar. I do believe there are changes in the Indian bar and things are moving forward. We do have, with all due respect, sir, an Indian bar for arbitration and its protocols. And I think initiatives like that do have steam. And well, DEI is important. I think there are standard forms within contracts that can help in that regard. If there is sustainable change to be observed, then why don't we look at contracts? And if it comes to court, then why doesn't the court itself mandate that you observe a panel which is reasonably allocated to the resources and requirements of the 21st century? And also stipulate time limits for disputes to end. I mean, otherwise, Mr. Sibal and his ilk are going to make an absolute mountain and continue making a mountain out of arbitration. Let's face it, arbitration is an answer and not the answer. And the courts must not stand between this and some sort of a resolution. And I think protocols, a construction protocol, arbitration commercial protocol is where the answer is. Thank you.
Thank you. I know everyone must be hungry, so I'll make this very short. This is a question for David Quest. Arbitrators often complain that drafting the procedural history part of an award can be extremely time-consuming and tedious. Are we now in an era where we could replace the procedural history with a blockchain where all the correspondence relating to the arbitration could be stored on the blockchain and readily accessible by the parties and by any subsequent court that may be apprised of the arbitration, whether there's a challenge or recognition of enforcement application?
Thank you. That's a very interesting question. When you started that question, I thought you were going to ask me something different, which was, given the, as you say, the burden many arbitrators feel in producing this, whether actually AI is a solution.
That would help too.
Because in a sense, I mean, that is. I know this has been discussed earlier, but that is one of the classic applications for AI in the arbitral process to assist in marshalling the material. So that may be one answer. As for use of the blockchain, well, and that's perhaps more appropriate where there is a need to ensure the security and validity and veracity of the process. But yes, that could perhaps be used too.
Excuse me, sir. My name is Surendra Kalra. My question is also to David, or about the blockchain only. You use the word tokenization in the arbitration process. We have heard that term only in Bitcoin, But how does tokenization come in the arbitration process?
Well, what I was talking about in particular in relation to tokenization was more to do with the status of the parties who were involved in the arbitration, because something that one increasingly sees is you have new business models where rather than having traditional companies governed by their shareholders, you have the governance rights vested in token holders, and the process needs to be able to accommodate that. You also, and the other point I made about where tokenization comes in is where people are trading tokens and then there's a dispute as to one or other trade, one may wish to have an arbitral process or a dispute resolution process effectively attached to the token, so that whoever ends up being the holder of it is able, when there is a dispute, is able to enforce a process agreed in advance.
You mean tokenization can be arbitrated if there is a dispute? Or there is a tokenization in the arbitration process?
No, I don't mean in the process itself. No, I mean these are giving rise to the disputes that arbitrators need to resolve.
Can I interpose something just to draw a couple of strands together, both that question, the previous question, and what was said earlier about specialized courts? I can't commend too highly the institution of specialized courts, and without blowing my own trumpet too much. So I'm the judge in charge of the Digital Economy Court in the DIFC, and there, for example, our procedure is that we have no procedure. The whole of our procedural rules only goes to the first case management conference. Once you get to the first case management conference, and we've truncated as much as we can within international conventions, the service and response to service, you get before the judge, presently myself, and then you tailor the procedure to the dispute. Because of all of the things that David mentioned, you have issues of whether digital autonomous organizations have legal personality. You have the tokenization issues. I think they call it pseudonymity rather than anonymity. Yes. on the blockchain. So you have to have a specialized court which understands all of those things and is willing to tailor procedures. You should not be tied to a procedural code that was written in 1908.
I think, if I may just add, I think that is absolutely at the heart of this, because there is a sort of expectation or a sort of default position that you have to have months of exchanging lengthy written submissions in circumstances where that may not be really what the litigants want.
Thank you, David. And with that, we bring the session to a close. Thank you so much.
Can I have a last question for Justice Muralidhar, please?
I'm so sorry, I can't really see the speaker. Can you keep it very brief, please?
Yes. Sir, Justice Muralidhar, we have noted your emphasis that solving domestic arbitration issues are the key, really. So my question is, what are your suggestions to make progress on solving these issues from institutional perspective, also from of the Arbitration Act, and also what your advice to the bar in Delhi, being a judge at the Delhi High Court? We are grateful to you for acknowledging that there is a strong and intelligent bar. What would be your message to that bar to transition into an arbitration bar from a predominantly litigation bar?
I think the second question I'll take first is professionalism, right? Be thorough professionals, value time, value your client's time, and just don't seek unnecessary adjournments. And follow the best practices abroad. The discoveries, all that happen without the intervention of a court. You don't need the arbitrator to facilitate discoveries if you're able to trust each other as counsel. Today, there's a complete lack of trust between opposing counsel. And we need to really work on that. First, in the first question, what we lack is accurate data on our arbitration proceedings. How many of our awards are able to withstand the scrutiny of a court? We don't have data. We don't have data on what is the time lag between reserving an award and delivering an award. We have episodic instances. I think Justice Kariel referred to some of them. Yes. Okay. And we don't know the delay in delivering awards. So the lack of discipline among lawyers percolates to lack of discipline among arbitrators. On both these fronts, we need to work hard. We have this change of counsel at the last minute when final arguments are to take place, which will end up in postponing. See, these are the habits of our court practice. We are carrying all these habits of court practice into arbitration. If we don't improve ourselves and we don't develop different habits for arbitration practice, it will not develop into a healthy arbitration bar and therefore better quality of awards. I hope I've answered your question.
Thank you, sir.
One second, please. I would like to add something. What are the best practices that are followed in an international commercial arbitration? Why do those practices break when it comes to domestic arbitration? The fault lies not just in the advocates who are appearing before the arbitrator. I think I'm loud enough. I think it's not just the advocates who appear before domestic arbitration, but also the arbitrators themselves, I would say frankly, how they would be in an international arbitration and how they would be in a domestic arbitration. So it's both sides. So if you want to have improvement in domestic arbitration, then please see that the best practices of an international arbitration, timelines, saving time, professionalism, everything applies even to a domestic arbitration. Then only you know the quality of a domestic arbitration will improve. I hope this is the last word on this topic.
Thank you, Your Ladyship. Before we proceed for lunch, I now invite Honorable Mr. Justice Tejas Kariel, Judge of the Delhi High Court, to felicitate Madam Chair and our esteemed speakers with a token of our respect and appreciation by presenting them with a Prabhavali. May we have a warm round of applause, please. A Prabhavali is a traditional ornamental arc crafted in intricate brasswork, symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring traditions of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend and the timeless elegance of Indian craftsmanship. On behalf of the Delhi Arbitration Week and the Delhi International Arbitration Center, thank you for being part of this important conversation. Thank you, everyone. I now invite you to join us for lunch. Thank you.
Thank you. Thank you.
Thank you. I have a presentation.